And for more insight on the California same-sex marriage ruling, we're joined now by FiOS 1 news anchor and legal expert Stone Grissom. And Stone, before we even talk about the case itself, almost as fascinating were the principles behind it. The judge who was arguing for same-sex marriage. Give an idea of some of the principles because, you know, 15, 20 years ago, this thing would have been considered an impossibility.
The judge is a federal district court judge. He's one of two openly gay judges in the United States. It's very interesting because he is an appointee from George Herbert Walker Bush, and he was considered a conservative moderate at the time. Now, what's even more interesting is that he was originally appointed by Ronald Reagan to fill the vacant seat, and he was filibustered by the Democrats, led by Nancy Pelosi of San Francisco, because she criticized him for being too critical of gay rights. And then George Herbert Walker Bush came and revised his nomination. He was unanimously confirmed at that point. So very interesting.
And we'll get into some of the language the judge ruled here because it was fascinating, very pointed too.
Right.
But also, the person arguing this case, Ted Olson, not exactly somebody who's going to be confused with a liberal.
No, this is probably one of the biggest conservative lawyers in the country. He represented Bush and Gore v. Bush, very strong advocate of conservative values. But you know what's interesting again about him is he took this case on principle. He even came out with a big op-ed piece and said, "Look, my colleagues." Conservative colleagues are wrong on this issue. He's very, very strong-minded on this particular issue. But again, it's an interesting makeup of players because it's not the people that you would think it would be. This is no ACLU case. This is, I mean, these are conservative people battling it out in the courts. So.
And the language in the decision, very user-friendly for both the audience and then also an intended audience as this will move up the court things. But just talk about, first of all, where the case moves from here because there's going to be a stay first, right?
There's going to be a stay. What he did is he struck down Proposition 8. And basically what he said is people can get married. Same-sex couples can get married in California. That's his ruling. Then he went in farther and said, okay, but what I'm going to do is I'm going to put a stay on that. This ruling is not going to take effect until it goes up the appellate chain. First, it has to go to the Ninth Circuit. No matter what the Ninth Circuit does, each side has a chance to appeal from that. We're in the federal system now, so from there it goes straight up to the Supreme Court. Depending on whether they put this on an expedited track, we could see this coming up in the next term very quickly, maybe in a couple of months.
And that's a transition here because from California, we then will be going to the Supreme Court. It's a matter of not if, but when, right?
Oh, it's a matter of when, yeah. Oh, yeah, absolutely. I mean, both sides have said this case is going to the Supreme Court. It's a very, very big case, it affects not just California. It's a statute in California, but it affects the entire nation on whether same-sex couples have the same equal protections as heterosexual couples.
And let's get on that phrase for a minute because that was in the judge's ruling. In his opinion, he said equal protection. And in fact, he took to task the actual voters in California who voted originally for Prop 8 said just because a plurality wants to legalize discrimination, it doesn't make it any more legal. Speak to that and speak about what equal protection says because we've got a history in this country about, you know, going up a curve here and then the public finally getting around it.
You hear this a lot on talk shows where people talk about, hey, you're going against the will of the people. You're an activist judge because the people have spoken. There's a poll out there, 80% say this. How can a judge rule for the 20%? Well, the Constitution is designed to protect that 20%. It's never designed to protect the 80% because they're a plurality. That's the whole point. 31 states have put same-sex marriages to the ballot, to the people. 31 states have rejected it. It's in the plurality. So we know that when you go to a state, the plurality is probably going to reject it. But that doesn't mean that it's constitutional. A plurality could say, look, in California, the voters by 85, 90% could say, look, if you're an illegal immigrant in this country, you're not a person as defined by the Constitution. Therefore, we can buy and sell you. Slavery can be legal for that. 90% of the people can vote that in as law. But the Constitution says absolutely you can't do that. Slavery is abolished by the Constitution.
And so we didn't even have to go to hypotheticals. We've seen in this country at times a black man and a white woman couldn't marry, couldn't have interracial marriages. You couldn't have, obviously, blacks and whites going to school together, separate but equal. We have seen what we look back now and say, my God, how did we do that? But at the time, the plurality was okay with that until the High Court got involved.
In the 50s, Brown versus Board was a very unpopular decision. The plurality would have said, absolutely not, we don't want integrated schools. But the Constitution said, well, that's equal protection. You have to allow that to exist. As recent as 1967, a third of this country had laws on the books. A third of the states in this country said black people and white people cannot marry. Think about that. Our president right now is the product of an interracial relationship that, as recent as 1967, wouldn't have been recognized in 1/3 of the states. How far we've come.
Wow.
And that's the difference between what a plurality says and what the Constitution says. That's not activism by a judge. That's a judge looking at the Constitution as what the Constitution says, not what the polls say.
Now let's talk about the judge's ruling, and not just the language and not just his recognition of the Equal Protection Clause in framing his decision, but he was speaking directly to justices. He was using justices' words on related subjects, Justice Scalia, but really his decision, or his opinion, many feel, was for an audience of one for Justice Kennedy, because we are in a 5-4 court land.
We're certainly going to have the same 5-4, 4-4 with that one swing vote, and Kennedy has become that swing vote. This opinion was very clever, and it did two things. One, it had a tremendous number of findings of facts, which the appellate courts really can't touch. In fact, his findings of facts go towards the social implications of same-sex couples, of same-sex families, of the effects of children. Those are findings of facts. That means the higher courts can't sit there and turn around and revisit that. They just have to accept it. Then he talks about his conclusions of law, and he applies those to these facts. And the fact that you may have a moral objection to same-sex marriages, that's a religious objection, or it's a moral objection based upon false data, that's not a compelling state interest. And he makes those conclusions of law, and that's what the Supreme Court's going to have to grapple with.
It's fascinating.
I
I know you're a huge student of history of the High Court, but one person in America, really, when you strip it all away, you know how 4 are going to vote, you know how the other 4 are going to vote. One person's going to decide what basically will become the law of the land.
Justice Kennedy is probably one of the most powerful justices right now, and one of the most powerful lawmakers. I mean, he's not making law, but he's interpreting that Constitution. He's the most important person in this fight right now.
Fascinating. Stone, thank you so much. I appreciate it.
Thanks.
All right, you heard from Stone, and when we come back,